The second point, I think that there was a lot of widespread support for, and that's getting money out of our judicial elections. Now, as Chip well knows, it's one thing to say that, it's another thing to come up with a way to do that because of the constitutional implications of the issue. But that's something we're going to be struggling with. And as I said, on December 18th, we're going to start voting. The commission, I think, has been very open-minded. They've asked a lot of good questions of the numerous people that have appeared before us. And I'm looking forward on the 18th to rolling up our sleeves and coming up with some good recommendations that hopefully will improve our system of justice. So, Chip, with that, I'm certainly open to any questions.
Thank you, David. Questions? And if there are no questions, that'll be the first time in the history of this committee that there are no questions. So
I think they're concerned about our recommendations.
They probably are, but they know how to ask a question because they raised their hand, and I'm sure somebody's going to raise their hand. And if you don't, I'm going to call on you. So so go ahead. Kimberly Phillips, unmute yourself.
Yeah.
Kim.
Thank you. Thank you. Thank you for that really great summary and context setting there, David. I guess one of the questions I have is, having received all this data and listened to all these witnesses, what would you say are the top 3 problems or challenges that we really need to remedy?
Well, I think the two of them I've already mentioned, which is improving the qualifications, the minimum qualifications of our judges, and secondly, try to figure out a way to get money, as much money out of the system as we can. And I think that one of our speakers, former chair of the Texas Ethics Commission, said that 40% of the money for judicial races come from lawyers. And I think that one of the issues has to do with how does that look to the public when you've got lawyers that are appearing in front of judges who have made substantial contributions to the election of that judge. One of the questions I get all the time from clients, particularly from out of state, is, do you know this judge and have you contributed to this judge's election campaign? And so it's really trying to come up with a way to get as much money out of the system as we can, so that people don't question the integrity of our judicial system. If we lose the rule of law and if we lose the independence of the judiciary, then I think that we have very serious problems. And so I think those are the primary issues. I think a related issue is under our current system. The problem is you have a lot of voters that don't know anything about the candidates. And I've told the commission this. I said, in Houston, where we have an excess of 50 judges running at one time, I don't know all the judges. So how can somebody who's not even a direct part of the system know judges? So I think those are the primary issues as far as I'm concerned. But that's a great question.
Thanks. Kimberly, you're the general counsel of a very large company. You and I have never had this conversation, but I have with others in your role. What are your thoughts about the fact that we have lots of money going to from lawyers, primarily, mostly, but also big companies, interest groups, that type of thing. Do you have any thoughts about that?
Yeah, a few. I think David touched on it. It's really the integrity of the process and the parties involved in the process, I think, is the question I ask most often. What are the relationships that are at play in the courtroom between the lawyers and the judges? And then how do I devise a strategy to manage that and to ensure that we are receiving a fair trial? I think the other question I ask most often, or the thing that I look at, David touched on as well, are the qualifications. is this a judge who's had, complex commercial trials before, and how is the judge going to manage the jury, and really looking at those qualifications. Like for me, it's beyond age and years of experience, right? I think it's looking more deeply at what really is the background of the lawyer who is proposing to become a judge, and how does that work for the majority of the disputes that, as a judge, that person will hear. Does that help?
Chip, let me add one point. I think the other thing that came through loud and clear from the judges and former judges that testified, judges hate asking for money. So it's not only that the lawyers don't like being asked for money, the judges hate asking for money. So you've got those that are direct participants in the system really don't like this whole concept of having to be asked or ask for money.
Yep, absolutely. In fact, we have somebody with kind of a unique experience in this regard on our committee. Kent Sullivan was a district judge. He was on the Court of Appeals. He recently was appointed as the Commissioner of Insurance by Governor Abbott. He has left that job. I should say he recently left the job. He's been on it for 3 years. Ken, I hope you're still on, and if you are, if you would unmute and unmask yourself and give us your thoughts about this. Well, it shows that he's on, but either he doesn't know how to unmute himself or he's stepped out. He told me he might have to step out for a minute to deal with things. So we'll hear from Commissioner Sullivan later. Does anybody else have any comments or questions for David Beck about the work of the commission?
I have one more reflection, Chip, if I may.
Yeah, Kim, absolutely.
And that is around the knowledge of the public around the judges who are on the ballot. I get a lot of questions all the time from family and friends. Who are the judges, and who should I vote for, or who should I not vote for, and why? So I think that is a real issue. But I think we also have to be careful not to be too paternalistic about the electorate, right? It's part of their job to understand all of the issues and the candidates on ballots. And so I don't want to undermine the rights that the electorate has to make choices in our system. But just another reflection.
Yeah, thanks, Kim. Robert Levy.
My question for David is kind of a deeper dive into the recent election and the impact of no straight ticket voting. Have you had a sense of what impact that might have made on judicial elections?
Yeah, that's a great question. We heard from Dr. Mark Jones with the Baker Institute in Houston, who we had asked earlier when he appeared before the commission to take a good hard look at the results and then report back to us, which he did. And the bottom line is that there really wasn't a whole lot of change. I mean, he quantified it and saying that, there was a small change, but the results were essentially the way they were before when straight ticket voting was permitted. And I asked him specifically, what did he attribute that to? And he really came up with two answers. He said, well, first of all, he thought that there was a lot of effort to educate people to actually vote down ballot. And then secondly, which I think is frankly an excellent explanation, he said that because of the pandemic and because you had a lot of earlier voting and voting absentee and so on, people had more time to reflect on the candidates. And so they took more time to vote. And so when they took more time to vote, they would actually go down ballot. Whereas if you're at a polling station and you're standing in line and you want to get out of there and it takes you an hour to get up to the machine, you want to vote and get out real quick. Well, you can't do that if there's no straight ticket voting. But he said that because of mail-in and so on and so forth, people just had more time. They're sitting around their kitchen table, going down. So I think that's the better of the two explanations, but those are the two reasons he gave us.
Was there more down ballot voting in the early voting as opposed to the election day voting?
I don't know the answer to that, Judge Bland. I just don't know the answer to that. I'm not sure he analyzed that.
That would seem to talk about whether that's a fruitful explanation.
Right.
Lamont Jefferson.
Following up, I was going to ask the question Robert asked, and then, but along those same lines, David, what did you hear? What did the commission hear about the, I guess, the worthiness of using party affiliation as a factor in voting? And what I guess really the question is, what's the argument in favor of we should retain, use party, have judges run under a party ticket?
The argument that I heard most, Lamont, was that if you assume that the electorate really is uninformed about who they're voting for when they're starting to go down ballot and vote for judges, if you have a partisan election with a D or an R in front of somebody's name, that's at least a signal that for some information. Now, what that tells you, I'm not really sure, but at least it's some information that a voter has, and whether that's, they assume that the candidate with a D in front of their name has a certain philosophy or an R in front of their name has a certain philosophy. I'm not sure, but I think that's the argument that I heard most of all.
We'll pick up with you in a minute, but in the meantime, Justice Christopher Carlson.
Well, two thoughts. One, you can't take the money out of judicial elections and still have elections. I mean, it's just not possible. And because you can't leave people without the ability to raise money to try and get some information out about themselves. And then secondly, it absolutely made a difference in our 4 appellate races, the end of straight party voting. So, I mean, if you look at it, you will see that it absolutely did make a difference. So in a close race, it's making a difference. In the trial court races, it didn't make a difference because they weren't close enough. But the numbers were different from the trial judges versus the Supreme Court judges, for example, in our counties. So more Republicans voted down ballot than Democrats did.
Judge, do you think the fact that an appellate judge deals with multiple counties as opposed to, say, one county, Harris County?
Well, no, I mean, that's why it made a difference, because we were close enough.
Right.
It didn't make a difference in Harris County because they weren't close enough.
Correct.
Yeah.
Yeah. Well, we have struggled with how to get information to voters about judges. One suggestion was we come up with a pamphlet. Well, the trouble is in Harris County, as you well know, there's so many judges, the pamphlet would look like Black's Law Dictionary. I mean, there's so many judges and you need to put so much information. Another suggestion was to have some kind of a website where judges could put so much information about themselves so people could go to it. Well, query, would people actually do that?
No, because those websites exist.
Yeah, well, I know, but it would be.
And almost every judge has a website. It's
Right.
like one of the cheapest things you can do.
Right.
To advertise your qualifications or, for people to find out something about you.
Right.
And people don't go look.
Yeah. And I think another suggestion was that somehow to try to get the money out, the state set up some kind of an apparatus where it would fund the elections. That's never going to happen. I mean, the cost would be so high, it would never succeed, I guess, basically is the best way to put it.
Well, and then, I mean, you can look at some other states where they have retention elections and judges aren't allowed to raise money. Well, then all you have are the PACs
Right.
that raise money and advertise for or against certain judges. And then the judge is left totally unable to present their side of the case.
No, I absolutely agree. And one of the arguments we heard in favor of retention elections, as far as the money concerned, is that yes, money would still be involved in a retention election, but would be far less than there would be if you had, just the current system, for example. The counter argument has been, well, what if you have a hot button issue where you've got special interest groups that are really being very active in a retention election because the judge has ruled one way or another on some kind of a so-called hot button issue? Well, the amount of money being spent on that election is going to, in my view, at least soar. So it's a thorny issue.
Holding up other people. But I appreciate the chance to say just a couple of words very briefly. I strongly endorse judicial selection reform. I will say from a personal point of view, it's been something I've been very interested in and supportive of since 1992. That was an election cycle in which I first helped in a really meaningful way a close friend who was running for district judge in Harris County. Candidly, I saw in a very up close and personal way what I thought was the ugly underbelly of judicial politics. I was a firsthand witness to things that I thought should never happen with respect to the judiciary or the legal system. Fortunately, he won, and I thought it turned out fine, but the process was simply not one that should have ever occurred. As you can tell, it is something that has been sort of seared in my memory, and I felt strongly about this ever since. I have participated in the system, been appointed twice. I have been on the ballot, and I have never changed my mind that this is a system that desperately needs to be changed. I will say that there are, perhaps many different approaches that would be good, but I'll just close with just a couple of very broad points. I had given a little bit of thought to this, and from my perspective, there need to be three sort of overriding principles we look at. We've got to have a high quality judiciary. That's a system that will produce judges of the highest integrity with excellent professional reputation, legal experience, and training. Our current minimum qualifications for someone serving, they simply don't do that. They don't come even close to that. So I think we've got to take a look at that. That's obviously already been referenced. We need an independent judiciary, one that really will facilitate fair and impartial judicial decisions based solely on the merits and unaffected by partisan or other inappropriate considerations. Our current system does not do that. And we need an inclusive and nonpartisan judiciary, a balanced system that facilitates selection and retention of a judiciary of the highest caliber, and that is one that's appropriately representative of a large state like Texas. Those are those are principles that I strongly endorse. I'm excited at the prospect of work product from the commission and would welcome movement forward, and will try and support it any way that I can. Thank you, Mr. Chair.
Harvey, take it away. You're quite welcome.
Thank you, David, for all your hard work and for your group's hard work. Just two comments. One, I just want to make it clear for the record that while you've had a number of defeated judges testify, and I was not one of those who's testified, those judges, my guess, have been advocating for change long before they were defeated. I mean, I remember that I was advocating for change and was on a committee that looked at this back in the 90s when Katie Kennedy, who was then the top-rated Democrat judge, lost. And I said, it's a shame. It shouldn't be this way. Whether you're Republican or Democrat, we need to do something different. So I just don't want it to look like all the new judges who won favor the status quo, and all the old judges who lost are doing so only because they lost. They've been advocating this for a long, long time.
Yeah, thank you. The great points, and I absolutely agree with them. One of the arguments that we heard from judges that were defeated, and I absolutely agree with your point, that many of them were already in favor of change even before they were defeated. But one of the arguments that we heard that, frankly, I hadn't really focused on is that when you have somebody that decides to leave their law practice and go into public service and become a judge, they're basically changing their life, and they're changing the life of their family. And they want some predictability with the new career that they're embracing. And it's one thing to say, okay, I do a good job, I work hard, I move my docket, I'll be rewarded, I'll continue as long as I want to do it, and then have something that's totally unforeseen happen and they're suddenly gone. And so their effort to do public service has suddenly changed. And now they're back to square one. And I guess I hadn't focused entirely on that point and the effect it has on judges, people who want to be judges, and the effect on their families.
And if I can just respond briefly, that is true completely. But one unique thing is you lose your clients too. So you not only are going back and starting from scratch, but most of those clients have been picked up by lawyers who have been now representing them for 2 or 3 years. And it's a little bit more difficult sometimes to go back and at least get the same quantity of work. So that's another burden on the defeated judge. Thank you.
Frank Gilstrap.
I have a question. First of all, we got rid of straight ticket voting, but we didn't get rid of partisan ID. I went back and looked at the Tarrant County vote. All the judges are D's or R's, all the candidates. As David points out, people had time. It was a big partisan election, and they had the one marker they could pick, which was, were they a D or an R, and that maybe drove the voting. We've gotten rid of the straight ticket voting. Why don't we get rid of the partisan ID?
Well, good question. And nonpartisan elections is going to be one of the methods that we'll be passing on and making a recommendation one way or the other as to the legislature. But nonpartisan elections is certainly one of the methods that we've studied and we'll make a recommendation on.
Well, let me just make one comment.
Sure, Frank.
Rather than making some type of sea change, we've gotten rid of the straight ticket. Why don't we take the next step and get rid of partisan voting and see how that works out, rather than just trying to come up with some new system? Because at the end of the day, we're dealing with two things. One is this long struggle between independent judiciary and a judiciary that's responsible to the people. The second thing is we've got these sweeps. I remember when we were all Democrats, then we all became Republicans. Now, who knows? If we got to fix one problem at a time. It seems at least with regard to the latter, we could take that one step and go on down the road. I know that where the resistance is coming from, because judges in counties where their seats are generally secure like to be identified with the dominant party. They all wanted to be Republicans for a while because that assured that they would get all the Republican votes. I say those days are passing and it's time to try something else. Thanks. Good
point. Thank you.
Thanks, Frank. Let me just ask on the record here, Marty, has Representative Leach called back in, or is that an old text you sent me? You have to unmute yourself,
Yes,
Marty.
Hi, Chip. I was following up on Pauline's chat, just trying to, but that is following up on her chat earlier. So they have not reconnected, no.
Okay, they haven't reconnected. Okay, that's great. All right, then Richard Orsinger is next. Richard.
Thank you, Chip. David, I got to watch one of your sessions. I thought it was very interesting. It's on YouTube if anyone wants to see them. I'm very familiar with the advantages and disadvantages of partisan election, but the old style Missouri plan, as they used to call it, I'm not too sure about the disadvantages. I've talked to a few lawyers over the decades that are not happy with the Missouri plan, but have you heard anything from people that live in states that use the Missouri plan as what the disadvantages are to qualified selection and retention?
Yes, the biggest, and the Missouri plan is something we've taken a look at. The biggest argument or complaint we've heard, Richard, about the Missouri plan is the so-called commission. As you know, that under the Missouri plan, you have a commission that will come up with nominees for the bench, and they'll recommend to the governor's got to pick one of those. And the big argument we've heard against that is the potential for that group to be controlled by, you know, one side or the other, if you will. And once that happens, then you're right back where you started, is you've got people that, you know, are all Democrats, all Republicans, et cetera, et cetera. So that's the biggest argument we've heard. And frankly, and let me just tell you that one of the methods that has been suggested for us to take a look at is an appointed system for our judges with a commission that'll be, and we'll be debating how you name that commission, where you might have the Senate appoint some, the House of Representatives appoint some, the State Bar appoint some, the Chief Justice appoint some, and so on. And then the big issue, though, is what is the role of the commission? Does the commission simply vet the governor's nominees, qualified, highly qualified, not qualified? Or on the other hand, does the commission say, Governor, here are 4 nominees for the Supreme Court, the one Supreme Court vacancy, you've got to pick one of them. And that's the big issue. And that's something we'll be debating on the 18th. But yes, we have had some criticism about the Missouri plan, but principally the way they select that commission.
Jump in.
Thank you.
With your comment.
Well, can you hear me now?
Yeah, we can hear you now.
So I actually, the comment right after you unsuccessfully tried to get me in before was and it did have to do with the nonpartisan nature of it. You know, David, I'm curious as to what your sense is as to how serious people are going to consider it. That's been, you know, the elephant in the room through all of these conversations, because as I sent a text to Chip to say a minute ago privately that if you look at any of the large cities, I think it was mentioned Fort Worth or so, but if you look at any of them, basically down ballot, people picked their party just like they did when it was straight ticket. But the straight ticket just did away with volume. It didn't, I don't think it did away with the change in people's selections. And until people are not identified by party, I'm just afraid in the large cities, in the smaller cities, as we all know in this conversation, they get to know who their judges are and it's not as critical. But in these large cities, as others have talked about during this conversation, and David, you said yourself, you don't know who all the judges are in Harris County. None of us do. Right now, because the Democratic Party is hot in the major cities, it is like it was, 30 years ago, 40 years ago when some of us started. I think in this case now, and in Harris County, the judges are decided by the primary. And the 2 Democratic judges that David bemoaned losing, both of whom were excellent, and I agree with them, and they're pretty well known to everybody in the county, in the legal profession, they lost in their primaries, not in the general election. And so as long as we are designating them by party, I'm afraid that judicial selections are still going to be hostage to whichever party is hot. And when I first started practicing, Republicans wanted appointed judges because there were no elected Republicans statewide. That's right. I see Justice Heck nodding. We unfortunately or fortunately started around the same time, maybe 1 year apart. And then so the Democrats were in power, they didn't want it. Then when the Democrats came out of power and the Republicans came in, Democrats for a long time wanted appointed judges. And now we flip back where predominantly Republican statewide government is talking about appointed judges. And I just think as long as we don't face head on this issue of partisanship, we're not going to make real progress. People will be picked by, if it's a one-party county like Harris County is right now, it's going to be picked in the Democratic primary. And if it's a one-party, statewide, it's going to be different in the smaller counties. So I'm curious as to David, as this thing moves along, are people really willing to tackle that issue, or is it still going to be a party designation?
Rusty, great comment. You're right. The elephant in the room is that on the party that's in power wants to do it a certain way because they have the power to do it. And suddenly, if things start to change, then the argument is, well, now you want to change because you see that you're losing power. I mean, that's kind of the elephant in the room. If you look at our history, there have been multiple efforts to change the system along the lines that you've indicated, and they've always been defeated. And primarily because of what I said earlier, the argument is people should have the right to vote for their judges. And it goes back into the Reconstruction area. The one thing that I think is different today that from times when you had Republican sweeps as opposed to Democratic sweep is today, at least in my view, we have a governor that is willing to endorse change. And we haven't had that in the past history. You might have had a Chief Justice of the Supreme Court like John Hill that advocated change. Well, he didn't really have the support of others. Had a lot of support, but not the support of, at least as I recall, the governor. Here we do have a governor, in my view, that is willing to embrace change. So the challenge for us is to come up with a way to embrace that change, do what's right for the whole system, and try to get money to the extent we can out of politics, and hopefully get the governor and the legislature to support this. We're going to give it a go. We're going to give it a go. Now,
well, I know Chip is on the committee, and I can't remember all the details, but perhaps because we discussed it over wine. But I know that he came up with, he thought that he had sort of a modified version of all this that he thought made sense. He was arguing very passionately over dinner one night. I don't know whether that's been discussed before the meeting, the committee, because I missed the first 15 minutes this morning, but and so maybe y'all have. But Chip, was there a suggestion that's been thrown before this committee that you were championing a few months ago?
Well, one of the suggestions that has come up, and we'll be taking a look at, Rusty, is whether to go to a commission. In other words, you start out with an appointed system. The governor will appoint judges, but they either have to be vetted through this commission, either qualified, well qualified, not qualified, or, as some are arguing, you have this commission, which is appointed and hopefully as nonpartisan as you can be, recommend to the governor who ought to be appointed. And then whoever that person is, after a certain period of time, whether it's 4 years, 6 years, or whatever, they've got to run in a retention election. So the people get to vote and determine whether they want them or not. And they wouldn't be running as a Democrat or Republican. They'll be running as a judge. And then people can either vote them in and vote them out, depending upon their performance. That's one of the methods that's being seriously discussed.
Isn't that similar to the California system, at least of a number of years? And I remember with that kind of system, the only time any judge was actually usually defeated, if there was, as y'all mentioned earlier, a hot button issue. Rose Bird, I recall, was identified as being against the death penalty during a conservative pro-death penalty period in California, and she was voted out, but only after a very, very expensive campaign, against her. I mean, what you're discussing it's tried in a fair degree of success in other states, isn't it?
Well, every state is different. Every state is a product of their history. California now has what they call the jungle primary, where everybody just votes, and then the two top go into the general election. Arizona, we've taken a look at. I mean, when you look at Arizona's system, I mean, it is a really hybrid system. And we talked about the Missouri plan. It's different than what we're talking about, but every state is a product of their history. And I think what we will come up with is probably going to be unique if we make any major changes.
And Rusty, that's because Texas is unique, and we don't have to follow anybody. And let me just say on the record here that I disavow any comments I made to you under the influence of 3 or 4 bottles of wine that you're pouring down my throat. But I will say, and it's no surprise to David, any member of the commission or anybody that's been watching our meetings, is that I think that the money, both the amount of it, who it comes from, and the frequency it's solicited, is corrosive of our system and erodes public support for our justice system. And I think we have to deal with that. And how we deal with that, as David says, is still on the table and open for discussion. So I hope I said that when we were meeting, but if I didn't, that's my sober thought about the whole thing. So Richard Munzinger, you are next. You will have to unmute yourself, and then there are 3 other people and maybe more that want to talk.
Mr. Chairman, do I get a chance to cross-examine Rusty Hardin at any point?
Yes, that'll be right before lunch.
Are you ready for me, Chip?
Well, yeah, as you know, hopefully you'll save us from this Beck Hardin kind of confrontation.
I won't repeat many of the observations that have been made, all of which have merit. The principal one, in my opinion, is that if you're going to have people run, they need to do so without a party label. But I want to go back to something that Dave said about requiring some kind of experience or credentials. I want to caution against that. I suspect Joe Jamel was not board certified. I suspect there are several people on this committee who have tried a lot of lawsuits and are not board certified. I'm one of them, civil and criminal. And it's not that I am necessarily qualified to be a judge, but I look at the Supreme Court Advisory Committee. There are a number of people that I've been on the committee for a few years. I don't know how many, but I can look back and I remember some of the people who are now on the appellate bench were on the trial bench, especially from Harris County. And I don't know how many of them had tried 6 or 8 serious jury cases before they took the trial bench, but I do know that those members of this committee had the credentials that were necessary to be a good trial judge, which are largely intellect and integrity. That's the real problem, is finding people of intellect and integrity who will take their oath seriously, that they will apply the law and the Constitution. But in any event, I do caution against putting some kind of arbitrary experience or certification level. One of the best judges that ever tried cases in El Paso was a real estate lawyer. And he took the bench many, many years ago. And we all laughed because he was a real estate lawyer. And we all laughed at him because we all thought he wouldn't know his left arm from his right. And he turned out to be one of the greatest trial judges we've ever had in this county, civil and criminal. Turned out to be a hell of a judge, a hell of a judge. And so you need to be careful about setting some of these credentials. I'm not so sure that board certification means all that much. It means that you took a test and passed it, and that's really what it means. I'm finished. Thank you.
Thank you, Richard. Chief Justice Christopher.
Sorry, I agree with Judges Steves and Richard that changing the qualifications is going to be something that is going to be very difficult. Perhaps, I don't know whether the committee has thought about the idea of, instead of changing the qualifications in the Constitution, or you might still have to do this, whether there would be sort of the commission to determine the qualifications of people on, a local level before they could actually run. And that way people could, take into account individual circumstances of a county versus an arbitrary, you have to try this many, number of cases. So that would be one way to give people a little bit more local control. With respect to the nonpartisan nature of elections, it always sounds like a good idea, but how do you do it in practice? You know, if we don't have partisan labels, so it would be like Houston City Council elections, where you'll have 10 or 15 people running for one spot. And then obviously you have to go to a runoff after that. I mean, it's not like only 2 people are gonna show up and get into a race. And to me, that would be an extremely difficult election to take care of. So, you know, nonpartisan sounds good until you think of what would really happen.
Let me ask a question and get your views on this. Under an appointive system, the person appointing will obviously look at the qualifications of the potential nominees or candidates, so that in a sense, they will look at determining what the background and experience is of somebody who may be appointed to the trial bench or alternatively to the appellate bench. So at least under an appointive system, you got somebody looking closely at the qualifications as opposed to having, you know, constitutional minimums and so on and so forth. I mean, is that something that you think is workable?
Well, I'm an outlier, I think, on elected judges. I've always thought that elected judges was the better system than the appointed system. And I've been lucky. I know I've been lucky that I have survived a number of sweeps in, you know, the various races that I have been in. But, you know, to me, there's definite advantages to having an elected system versus an appointed system. So I think I'm an outlier probably on this committee.
Okay, thank you.
Pete Shankin.
Hi. I want to thank David and all of the people on this call who've been working on these issues, many of them for decades. Two people have already stolen the way I wanted to start, but they only did it halfway. They talked about the elephant in the room. There actually isn't an elephant in the room. There's an elephant and a donkey. And we've just had a dramatic intensification of partisan alignment in this country in this last election. There is some hope, I think, of ameliorating that. I see very little chance of our, at least in the short run, even getting back to the wonderful, idyllic level of bipartisan cooperation we had in the last 10 or 15 years. So I'm deeply skeptical of our ability to pass in whatever technique it takes, whatever the steps are and whatever the vote required is to make these changes. I had separately used the chat feature to ask Chip if he could relieve me of the burden of my ignorance here. I don't really know quite how this process works, but I gather we've got to pass a constitutional amendment to do anything real. And I just want to suggest that as long as all we're doing is saying in this constitutional election, we're going to fix the problem of partisan judges by creating a system in which a governor elected by one party, and everybody voting will know who that governor is at the time, which party, and will have whatever views they have about how likely that is to remain the same, is going to make all the choices. With what Rusty is rightly saying about the politics of the big cities, where an enormous number of the voters are, do we have a snowball's chance in hell of actually getting this done on a big scale? I think not, unless we're prepared to go a whole lot bigger as part of a package of nonpartisan or reduced partisan fairness measures that address the ones that are of greater urgency to the party that doesn't have power now, but is quite hopeful that in the next 2, 4, I don't know what the actual realistic ambitions are, they will. And that would be measures to greatly restrict the scope and effectiveness of gerrymandering in legislative elections, state Senate, state House, congressional, state Board of Education, and greatly cabin the restrictions on registration and voting that can be adopted or maintained on a basis of prevention of voter fraud. If you had a package deal that was nonpartisan, bipartisan on all of those elements, and you were able to go to an election on that, I think you might find a substantial majority of voters in both, aligned with both parties, who thought that would be a big improvement over what we have now and might vote for it. Without that, I don't see how we get there. And I know that's more like a speech than a question. And I guess what I'd like to do to turn it into a question is, David, can you talk me out of that pessimism?
Good speech, Pete. Good speech. You know, whatever we recommend, as you well know, goes to the legislature. And then what they do with it, who knows? And assuming that they adopt in one form or another whatever we recommend, it's in all likelihood going to have to require a constitutional amendment where the people will vote on it. Whether that's going to pass or not, I have absolutely no idea. The only thing I can do and the commission can do is do what we were asked to do, and that is to analyze the advantages and disadvantages of various methods and make our recommendations. And that's what we're going to do. Whatever happens after that, I have no idea. I don't think we can make our decision based on what we think will get through the legislature, and then in addition, what we think might be acceptable to the people of Texas, because I don't think anybody really knows at this point.
Judge Wallace.
I just, first of all, I want to thank David for all the work he's done. If they get this solved, I hope he will go to the Middle East and figure out a plan to bring peace to the Middle East. But as someone who drew a primary opponent in the 2016 election over a hot button issue and won an opponent who was very well financed, I've given hours of thought to this, and I don't know what the answer is, really. I do think this, though. I agree with Justice Christopher. If we're going to elect judges, either nonpartisan or partisan, you are not going to be able to take the money out of running for election, because the only hope you have is some kind of name recognition. The general public doesn't know how good or bad a judge you are. And it's all about trying to get your name, and that's why you see all these tacky yard signs and handout, and that costs money. And so I just think that those are mutually exclusive proposals to continue elections, but get the money out of the elections. That's for what it's worth. Thank you.
Thank you, Judge.
Thank you, Judge. Stephen Yalanowski, who all of us know, and David, you probably do too, is a longtime district judge in Travis County. And Stephen, are you still sitting as a visiting judge, or I forget? But
yes, I am.
You're recognized.
Yes, I am next week, in fact.
All right. So Judge Yalanowski.
Well, I have every reason to be a champion of the current system. I ran unknown, unqualified by any objective standard, yet I won the contested primary, and I won the general election by defeating an excellent judge appointed by a Republican governor. But I was in Travis County, and it was a sweep year for Democrats. The only reason that I won the general election was because about 56% of the winning candidates were Democrat, or the Democrats won by about 56 to 44. which is what I won by. And I won by that simply because of the Democratic sweep. So I am not a supporter of elections, unlike Justice Christopher. I think voting for judges is like having the county community vote for the pharmacists who serve us in the community. That's just the same thing. I think we're about as educated generally about judges as we are about pharmacy. And even the voters who happen to hit upon something that's a judicial issue, it's the wrong judicial issue. I remember running where the hot button issue, quote unquote, was abortion. Well, I mean, Roe v. Wade is a US Supreme Court decision. A lowly trial judge in Travis County has nothing to do about that. Yet that was on people's minds. So I'm in favor of something that involves appointment, but more importantly, some kind of nonpartisan commission. And I think we need to get over the value, which I think once had, but no longer has, of a popular vote for judges for the reasons that I just said. We have plenty of people in power who are not elected by the populace. The legislature votes for certain people or approves them or confirms them, but there's no popular vote for the cabinet, for the president, for instance. Very powerful people. So I think that we've got to come up with something other than election. I think in the past, given that we had nothing to go on other than party, that's why we needed a party. But what's happened in the primaries, as I think Rusty said, it becomes a fight in the primaries. And what's happened, at least in my experience with the primaries, all along in Travis County, because it's a liberal county, what people vote on before they get to the general election, in the primary, they vote on apparent race and apparent gender, if they know nothing else. Now, Travis County being liberal, you can imagine what they're looking for. And in fact, you can correlate the winning people who won in the primaries with those things. For example, women do better in Travis County, and thank God for that. I'm all for more women, but the comparison between a man and a woman needs to be considered, a particular man and a particular woman. One example is all the women won in the primary, except one person, one woman whose first name was ambiguous as to whether she was male or female. That was the only difference that I can see. In another primary, the most respected, highly rated judge of another, I guess he was 10 years by then, was defeated by a woman who was qualified by trial experience, but had been determined by both a state court and a federal court to be a vexatious litigant. And that information obviously was very important. Could not get that information out to anyone. So in the past, the primaries had some value to them because, at least in Travis County and probably elsewhere, the party clubs, or at least the party mechanisms, help people understand the true qualifications of somebody running for judge. Because the party activists understood that, and they would recommend who to vote for in the primary. But that doesn't work anymore. There's too much information that clouds up the information like that is useful. People no longer do as they often did in the past, look at one source of their preferred paper in Travis County, not the top media, but kind of Democratic leaning paper. Everybody looked at that for who to vote for judge. That doesn't work anymore. There's too much information. So people are going off what I just said, apparent race and apparent gender. So I really think we need to get away from election altogether. And I said that even before I was elected, and when, as now, there was a Republican governor. So I would campaign to the extent I can as a visiting judge for some kind of commission appointment, even though, as I said, there's every reason why I would, given my experience, support the opposite.
Thanks, Judge. Great comments. Thank you. Rusty.
Yeah, let me ask you if there's a way sort of around this. And all due deference to Justice Christopher, if she'd been running in only one county, she would not have been as fortunate as we would hope her to have been if she was running in one of the big counties. I think, again, we come back to the big counties. I don't know what what we call a smaller county, let's say 150,000 total. I don't know what the number is, but if there was a way, and I don't know that this can be done, but David, I wonder if it's been discussed, or is there if there's legislative way to perhaps with each party be required to have a screening commission in their county or so? I don't know. I only thought about it as we're talking here, because I'm very pessimistic that we're going to be able to get the two parties out of it. I mean, I talked about nonpartisan, but I don't see people agreeing when you start having to have 2/3 here and there. Having said that, I think that part of the concern is if one party is the dominant party, whether it's Republican or Democrats, and as we already said, we've seen it both ways here. If there is a mechanism for each party to be required in some way to screen who their candidates are to have that endorsement, people may give lip service to it now, but they don't really do it. And maybe that's at least enter between, however, whatever system we come up with, that can at least improve the quality potentially of the candidates. Has there been any discussion ever about that type of idea?
There has been discussion about setting up local committees or local commissions, if you will.
Okay.
And that, in other words, it would be a trickle up where you have the local people, say from Houston, and the challenge, Rusty, is always, well, all right, how do you select the members of that local commission or commission? And you're going to have to come up with a way to recognize which party's in power and which party's not. For example, this is just off the top of my head, if you had a 15-member commission in Houston, for example, you could have the Democrats having the majority on the commission because they're in the position now where they seem to be in the majority with respect to elections. But in the same time, you would set the criteria by saying, somebody must have certain type of experience, qualifications, diversity. I mean, you'd have to weigh all of those factors. But yes, it has been discussed. Nothing's been decided yet. And that's why I've been kind of making some notes from a lot of the suggestions that you and others have made this morning, which are very helpful. But yes, it has been discussed. The challenge is, how do you select that local group?
Right. Thank you.
Judge Esteves.
So I want to piggyback on something that Judge Peoples had asked about right at the beginning. And it just, when Judge Yeleneski was talking, he made the comments that, yes, these things used to work, but they don't work anymore. And I want to suggest that it does work in some parts of the state. So as Judge Peoples had asked the question about, had you looked at a different or allowing these counties or districts to decide which way they wanted to go? And I would just make a suggestion that you could give perhaps the bigger counties, and I know that Rusty had asked, well, what's a bigger county? And when I was running, the number was 250,000. So I was under the less than, if your district was less than 250,000 people, then I was under different rules under the Texas Ethics Commission. I couldn't raise more than $1,000 per person or household or law firm. And so we had different rules. And so I think that it would be prudent to look at maybe raising that district number to 300,000 and then allowing those that have 300,000 or less to decide whether they want to have elected or vote. Because those people still do have a meaningful election when it comes to judges. And I think that if these races were meaningful it would be the preferred way to go. I don't think there's a question about that. And I think that's why Justice Christopher is saying, well, it's still meaningful for me. It was meaningful for me. And then, but it wasn't meaningful at all for Judge Yeleneski and some of those in Houston, because it didn't matter. It didn't matter that they were more educated, that they had more experience, that they had, you know, a great desire to serve, because nobody really knew. They couldn't get that message out. But when you're talking about districts that are less than 300,000, maybe it's 500,000, or maybe you stick to the 250,000. Those are meaningful elections, and you really are taking something away from the people that you may not be taking away from Harris County or Dallas County, but you are taking away from these districts. And I want to say districts because it's not really a county. I know it, you know, some of my judges under in our region, I'm in Region 9, they serve 5 counties. I think that's the most. I might have one that has 6 counties. I mean, that's a huge area. You know, and if somebody, you know, they should be able to elect them, because that might be 6, that there's still less than 100,000 people, and those people go out and it's important to them on who they're going to vote for.
Yeah, thanks, Judge. There was a bill introduced in the last session of the legislature by Representative Brooks Landgraf, who happens to be on our commission. And his bill would have set up an appointive retention system. And he made the distinction between the big metropolitan areas and the rural areas. And I don't recall whether the number was 300,000 or 500,000, but it was one of those numbers, so that your area would not be affected by his particular bill. In other words, it would only apply to these so-called large metropolitan areas, as I recall.
Well, I would suggest that, you know, in our region, we have 2 counties that would be larger, and that would be districts, Potter and Randall County. So some of those courts, and Lubbock County. They may want to go to an appointment system. I don't know. I know what I feel, you know, just because I feel they're meaningful, they may feel differently. So I don't think it hurts to give them a choice. You know, they may want to do that. Some of the larger counties may have enough people that think that's the best way to go. So I would give them a choice on all of them.
Thank you. Good suggestion.
Levi Benton.
Thanks, Chip. I want to.
Who everybody knows was a longtime district judge in Harris County. And I don't believe you lost your election, or maybe you did, but anyway, now in private practice.
Yeah, I lost in a sweep, and candidly, I don't know. I guess it's all in the details and what's proposed on how I feel. Got mixed emotions, but I want to make some random comments. You know, what I haven't heard, I don't think even from David Beck, who I regard as a friend, I haven't heard this morning that anyone's done any study of any number of cases of judges tried by judges deemed to be unqualified, and compared those with cases tried by judges deemed to be qualified, and tested the perception of the correctness of rulings or the fairness of the outcome. You know, because if this is all being driven by we're concerned about judges who aren't qualified. Well, why are we concerned about that? Who has this concern about the correctness of the outcome, or the fairness of the correctness or fairness of the outcomes? And that we haven't even talked about that this morning. David and others have talked about, you know, the person appointing presumably looks at qualifications, but we see both on the state level and on the federal level often, well, that just isn't true. We have in our working lifetime, people appointed to the highest court of this state who have never tried a case as a lawyer or as a judge, never argued a case to a court of appeals, and that's certainly true in the federal system. So, you know, The only thing that's really been said today that I can co-sign that is something said by Commissioner Judge, my buddy Kent Sullivan. We all want judges with integrity, independence, and inclusiveness. But I don't think any of the comments or proposals that we've heard today necessarily guarantee that we get to a higher level in any of those areas. So that's all I've got to say. Thanks.
Thank you. Thank you, Levi. That comments are thoughtful and well taken as always. David, you have been very gracious in giving us your time this morning, and I think this is has been a terrific discussion. We will have a transcript of this prepared by Dee Dee shortly, and I think I might suggest that we send it to the other commissioners on our fellow commissioners, so that they can get the benefit of it if they choose to add to their pile of reading. But in any event, thank you again. We're going to take our morning recess, but if John Day could stay on the line with Jerry Bullard for me with a minute, so we can figure out how we're